So, a scorching political, financial crimes and legal heat wave that's billowing out of Kogi State, threatening to engulf the immediate past governor of the state, Yahaya Bello. Temperatures touched their highest level after the EFCC accused the former governor of involvement in the laundering of more than 80 billion naira belonging to Kogi State and of withdrawing nearly $1 million from the coffers of the Kogi State government to pay his child's school fees in advance. The EFCC claims to have tons of evidence and suggests that nothing can save the doomed fate of Yahaya Bello, not political interference and not a complicit judiciary, if there is such a thing. Mr. Bello, on the other hand, has been waiving a court order that he procured that prevents him from being arrested and prosecuted. Sounds a bit like the theatre of the absurd, doesn't it?
Particulars of offense is there. It's before court. Go and check it. Apply for our processes, please. You will get some of these particulars of offense there. Move money directly from government to bring the change. Use it to pay the child's school fee in advance. In advance. Dollars. How much? 70 what? In dollars, yes. In dollars. I think $72,000. $720,000, sorry. $720,000 in advance. In anticipation that he was going to leave government house. In a poor state like Kogi. And you want me to close my eyes to that? Under the guise of saying I'm being used. Used by who? At this stage of my life? Used by who? By who? For crying out loud. I assumed office here. I didn't initiate the case. I inherited the case file. I called for the case file. I called for the report. And I said, look, there are issues here. Do you know on my honor, I put a call across to him, which ordinarily I'm not supposed to do, just to honor him as a governor, as a immediate past governor. Sir, there are issues. I've seen this case file. Can you just come? Let us clarify these issues. I'm under camera. He said, sir, I thank you, my brother. I know, but I can't come. There's one lady, I don't know what her name is, maybe a senator, that she learned she had set, she has surrounded the EFCC with over 100 journalists, to come and embarrass him and intimidate him and all kind of stuff. I said, okay, if that is your fear, I'm going to pass you through my own gate, special man's gate. You will come to my floor. We will accord you that respect. I will invite my operatives. They will come and interrogate you or interview in my own office. What could be more honorable than that? In my own office. To allay the fear. Thank you, sir. I appreciate that. You know what he said? But can't they come to my village?
Well, if Yahaya Bello wants to send someone from his village or turn up from there, gives us the privilege, we'll be more than happy to talk to him in order to balance things, because obviously we've just heard from the EFCC there. Well, for more on this, I'm joined now from our studios in Lagos by the lawyer Liberus Oshoma, and here in the studio in Abuja by the human rights activist Austin Okai. Mr. Oshoma, thank you very much indeed for taking the time. I understand you had to run around a bit to get ready for this evening's program, but we value your legal analysis so much that we were prepared to wait. Only the best, of course. Thank you very much indeed. Let me start with you in Lagos. There was, of course, there has been conflicting court orders. There's been that press briefing. We just saw a bit of a response to that. Questions about whether Mr. Bello was formally invited by the EFCC or not. What's the clearest legal assessment that you can give us on this nettlesome case?
Last time here, I said that we all understand the modus operandi of invitation, the way legal or agencies of government or security agencies extend invitation. Even these days, court has ruled that a registrar's call to a lawyer is as good as hearing notice. But that said, there is something very germane here. You said something just now that you will be more than happy to meet Yahaya Bello in the village to interview him. If the first question is, why would somebody rush to court if, he is not in the picture of all of these issues? EFCC puts Yahaya Bello in the picture by that call. Oh, my brother, come, there is an issue here, let us iron it out. And yet, this is the same man you said has amassed state fund to the tune of almost $1 million. You are calling him to come through the back door for interaction so that you people can iron it out. And the man said, come to my village. The security agencies we know can go to the extent of even more than your village to come arrest you. Section 46 of the Constitution says, if you permit me to quickly read, so that we can carry our listeners along, our viewers, sorry. Any person who alleges that any of the provisions of this Constitution is being or likely to be contravened in any state in relation to him may apply to a high court in that state for redress. So once you do all of this, you make call, you're begging him to come. Let us resolve the matter. A matter you said is so grave as taking money from the state. You're begging him to come through your back door. If you remember, some former governors have accused the former EFCC chairman of allegedly demanding money from them. So I expected that the EFCC chairman should have learned from this instead of extending a backdoor invitation. The moment the person refused to appear, you do a formal invitation to that person, and that document will not lie. Now, you try to smuggle the person through the back door, and the man has said, well, show me invitation, show the invitation, who received that invitation. There is none. And another thing is that you now come, after all of this, you couldn't even go send your operative. Okay, you want to interview him or you want to arrest him. He says he's in the village. You didn't even send your operative there to say, okay, go and arrest him and bring him to me. You said, no, I will not. You left him. And then the man rushed to court in fulfillment of section 46(1) to say, well, the way things are going, I need to protect my right. He got an order. You filed a 7-paragraph affidavit against that order. He got an order. You appealed the order. While the appeal is pending, you now went to another court. You filed a charge in another court, in the Federal High Court, and then you asked for a warrant of arrest. And what that might likely mean is that the court where you obtained the warrant of arrest, with what had happened yesterday and the argument back and forth, the tendency is that the court where you obtained the warrant of arrest was not in the know of that court of appeal, pending court of appeal suit between you and the applicant. So all of these are what is leading to all of this conflicting judgment. And to save face, I think what the EFCC is basically doing now is to save face. And in trying to save face, also, the chairman has further, exposed the underbelly of the accusations that people had consistently thrown at EFCC when it comes to trying a politically exposed person. They give them, they deodorize them. But when it comes to, the everyday person, the Yahoo person, you use insecticide. Why do you need to take him through the back door? What if the man comes tomorrow and say, well, you wanted to collect something from me, that's why you were taking me through the back door, and I don't have to give. Okay. And the EFCC chairman admitted publicly that he wanted to take him through the back door. So for me, legally, all of these positions, procedures are faulty ab initio.
Right. Okay. Well, thanks for setting that out and giving us the legal assessment. Let me come to you, Austin Okai. You are a human rights activist. In terms of propriety, I mean, Liberace Oshoma talking there about the EFCC, but it's not just the EFCC that's got to be seen to be doing the right thing, is it? I mean, Yahaya Bello is a former governor. For someone who's risen to that high rank, you would assume that they would live in conformity with the law and propriety. And if, as is clear, the EFCC needs to talk to him in order to clarify things, you would have thought that the former governor would not need to be hounded in order to make himself available. I mean, why would he go and get a court order preventing the EFCC from arresting and prosecuting him and taking him to court?
Yeah, thank you again. Thank you, Nigerians. I read what the lawyer said, and I think that some of them don't know Yahaya Bello. He's one of the sophisticated governors that you can't just approach. So saying that who give an invitation, we are all aware of this case. And it started since 2022, when 20 billion naira of Kogi State bailout fund was found in the Sterling Bank. The state government denied that money. The EFCC ordered Bauer, they refunded that money back to CBN. After then, there was a case of February 2023, to the 2nd of February 2023, where the same EFCC order Bauer got a court order where so many of his assets, up to 14, including Dubai, Maitama, so many places were asked to forfeit it to the federal government of Nigeria by the EFCC order. So the case is not now. As the chairman said, he inherited the case. He called on the file and he asked the governor, there is a problem here. The court order the governor obtained, the former governor of Kogi State obtained, is about his fundamental human right. And I am not aware of any court order that can stop Economic and Financial Crime Commission from investigating the criminal offense. What court order did he obtain? From where? A high court in Kogi State. Who are those judges? How neutral are they? He appointed them. He was a former governor of that state. Now, there is a warrant arrest. And nobody can say that, just as I want to disagree with my colleagues in Lagos, that the judge, the warrant was completely, the man may not be aware of the pre-existing court order. The court order ask you not to honor an invitation? Was he arrested? He was invited. You mean you are the governor, a custodian of the state, where over billions of money has come to that state for 8 years. And there was a petition to that effect. And they are asking you to come and give a stewardship of what happened. And you are running away. Why is he running away? That means there's more to this. So I think the EFCC should be commended for even approaching court to get a warrant of arrest. They have a right to arrest since he refused to honor invitation. And he, the governor, is aware. He arrested so many of us because of that. So what is he talking about? He's supposed to come out from his hiding and go and clear his name, just as Professor Sesage said. Come out and go and honor clear your name, except there's more to what we do not know. And just as the chairman of Economic and Financial Crime Commission said, that he won't mind resign until he sees the conclusion of this case. That means there's more to the case that we are not aware of it.
Right. Okay. Well, I'll give you a chance there, Mr. Oshoma, to respond. But whilst you're doing that, obviously you're wearing your legal hat. And let me just get, because I mean, a lot of us are not as legally up to speed as you are. There are clearly conflicting court orders, aren't there? I mean, Mr. Bello's court order prevents him from being arrested and prosecuted. The EFCC is challenging that order, but the EFCC already has a court order to arrest Mr. Bello, or at least to invite him, but a contrary argument has been made to that in court, and the ruling has been adjourned. In such circumstances, how much of a legal muddle are we in there? And who's got the right of it?
You see, Charles, thank you, you brought up this issue. But before I quickly answer that question, let me say here that everybody wants a former governor that has dipped his hand in the till to be prosecuted. So when I also listened to the chairman saying, I will prosecute, I wasn't impressed. Nobody is waiting for prosecution. All we want to see is conviction. As I speak to you now, as the Master DG, 8-point-something billion discharged and acquitted against EFCC. As I speak to you, after 5 years, the same EFCC, after arresting former Attorney General in a Gestapo manner, they said they have no evidence against him. Meanwhile, he was prosecuted for 5 years. So I don't just want to see prosecution. I want to see conviction. And so, like my colleague has said, this matter is not a new matter. Not being a new matter, I don't think EFCC would have first and foremost gone to press or extend backdoor invitation. If you extend backdoor invitation, that means you don't want to prosecute. What you should do is, like they have done with other cases, we've seen Bobrisky's case, what you should do is ensure that you cross your T's and dot the I's. When you extend invitation and the man says he's not coming, and you send a formal invitation. If he says, come and speak with me in the village, if the matter is so grave, and you truly want to get conviction, you take the whole hog to ensure that you go speak to the person. But when the matter becomes to a media discussion, the tendency is that this suspect that you're looking for will run to court in compliance with Section 46(1) to want to enforce his right. And here is the issue now. After enforcing that right, the court says, we hereby restrain you from harassing, persecuting him. Now you have gone to obtain a court order, to a warrant of arrest. And now the warrant of arrest is a subject of debate or litigation, argument. After that argument had been taken and the court had reserved a ruling on the warrant of arrest, what it means is that EFCC at this stage can no longer take any step on the matter because you've submitted to the jurisdiction of the court on that warrant that was issued by the same court, because the warrant you're trying to enforce here was issued by the court, and that court, there's argument, there's what I will call an appeal by the other party now that you can no longer enforce this warrant because you have served us a charge. And the other party says, no, whether we have served you a charge or not, this warrant must still be enforced. So the court has taken argument and has reserved judgment. So not to foist a fait accompli on the court, parties will have to maintain what we call status quo. If the EFCC did not boggle this case ab initio, you wouldn't have had a case where the man will rush to court to get an order against EFCC. Did Bobrisky rush to court to get an order against EFCC? Did Kobana chief priest rush to court to get an order against EFCC? Because they were not aware. The element of surprise that security agencies are known for is taken away when security agencies first go to the media, address the media, tell us how they want to arrest, how they will block the air border, the land border, the sea border, and the rest. Last time I was here, when I left here, some senior advocate called me and said, look, it is as if EFCC is not prepared before they go to the media. One, Ade Adedeji, quote me, senior advocate, got 15 judgments against them. Ozekome, 11 judgments against them. Why do we want to keep funding an agency when the people, the politically exposed people that we expect them to prosecute, the first thing they do is to go to the media, tell them we are coming, we're coming, we're coming. And then these people run to court, get an order to protect them, and then you now say, no, you don't want to enforce this order. You don't want to obey the order. So we should clap for you and we should be happy. As a lawyer, I should be happy. I expect you to be diligent in prosecution because prosecution starts from investigation. It is how you investigate the matter that will determine prosecution. When you don't, and if there's any doubt in the mind of the court, it is resolved in favor of the accused person. Take, for example, also in the media had been discussed the charge sheet. My colleague in the studio talked about 2012, 2020, 2023 monies that were forfeited. Fantastic. I want to see all of these issues brought before the court. I want to see parties' argument on it. I want to see what Yahaya Bello's defense would be. But a situation where you are now extending backdoor invitation to him. Oh, come, my brother. Right. Let us discuss this thing. If it is Liboros Oshoma, will you extend backdoor invitation to him?
I think you made that point, and you do have some important things that you're saying there, especially given
and quickly,
the legal parameters.
On the issue of obeying court orders.
Yeah. Go on.
On the issue of Yahaya Bello submitting himself, for interrogation, like I read in section 46(1), I don't know what would have played out between them because the chairman now has said, I called him. I don't know the conversation they had. For the man to now say, well, I do not have faith in this call. Let me go to court for protection. You caused it. Why do you think in some cases, when the court now gives an order to that person to protect him, why would the person want to submit himself to EFCC when he has approached the court? What was the essence of approaching the court in the first place? Because he feels, I feel threatened that my rights might be violated. So he went to court because that's what Section 46 says. And so you don't even give that window of that feeling of your right being threatened. The moment you give that window, the person goes to court. Once an order is issued in favor of that person, you don't expect the person now who got an order to violate the order by saying, no, I will not obey this order protecting me.
I think you've made that point, and you've made it very well indeed. But let me bring in Mr. Okai here, because Mr. Okai, you are, of course, speaking, let's call it vox populi, on behalf of the people of Nigeria, the people whose commonwealth is, we've seen many, many times, being taken away for personal use. And so you're perfectly right in feeling incensed and angry about this whole situation. But I do understand where Mr. Oshoma is coming from, because we must all live under the rule of law. Otherwise, it'll be anarchy. And what I need to ask you, Mr. Okai, is, I mean, given the fact that they've both now gone to court, the court has adjourned, and everybody's waiting to hear what the court decision is going to be. Mr. Bello has now been served, apparently. Does he need to be picked up by the EFCC, or could the EFCC just give him that allowance and wait for him to appear when in court, if he's needed in court?
He knows what he's doing. Why is he running? EFCC can pick him any moment from now, because it's an enforcement agency, not a service organization. The order, just as I said, I was expecting my colleagues in the other side to address what type of order, what kind of order did Yahaya Bello obtain? That he shouldn't give account of the stewardship of the state he governed for 8 years? Or somebody will take advantage of some discrepancy, or because a judge will sit down somewhere and give an order that the governor should be questioned? A man who governed the state for 8 years, and there are clear evidences, prima facie, established against him. So now, okay, you know that before you say EFCC should have picked him before now. This man left as a governor, he was living with not less than 17 SSS, DSS, about 20-something armed policemen guiding him. And you saw what happened in Zone 4 when they came for him. You saw how he was prevented until the governor and colleagues, I mean the man he handed over to, came and took him away from there. Okay, what would have happened if the EFCC enforced law there? Somebody would have died. And at the end, we say that the EFCC do not act according to this or that. We should ask the governor, the former governor of Kogi State, as a custodian, a man who once swore to defend the oath and the Constitution of the Federal Republic of Nigeria, let him live by example, by honorably submit himself to the EFCC, or we are asking EFCC, the people of the Nigerians, the ordinary citizen, that EFCC shouldn't be restrained by anything. Let them get him. This is a criminal offense. And a man who committed a criminal offense cannot be seen hiding in the name of any court order.
He hasn't been found guilty yet. Let's make that
but let him go and clear himself. Even if he's not been found, it's left for him to explain himself. And that's what we are all begging on him. If he's not honoring the EFCC, who else will he honor? Attorney General of the Federation, who is overall the man in charge of the criminal cases in this country, has asked the governor, the former governor of Kogi State, to honor the EFCC invitation. And if we encourage this thing by court order, then what is the need of having the EFCC? The governor is aware that a day like this will come. EFCC never addressed any media. I do not hold brief for them, but I'm following this case as a citizen of the state. There was never a time EFCC addressed any media about this case before now. And the first time EFCC addressed the media was the day they filed a case over when it was mentioned. And he knew. The first thing the governor did is to use the successor, the commissioner of Kogi State, that the Kogi money did not miss. When we all know, for 80 years, this man has never paid his salary, any worker's complete salary in the state. The primary school, the secondary school, the local government secretariats are not functioning. Nothing is working in Kogi State. He has judiciary in his arm where he obtained one court order from. He has the legislative, the state assembly in his pocket. You heard them a day before yesterday, sat down and said that they want EFCC to leave the man, to remove his name from among the wanted list, which I know EFCC will not do that. The people are calling for justice. The people are calling that the man should be questioned. Come and give account of what happened to the billions of money you received for 8 years. This is simple as A to Z. If he's not guilty, why is he running? EFCC should go after him, just as their lawyer said. The whole money is using military. He's hiding the governor's house in the government house in Lokoya. EFCC should go after him, or the president, or Attorney General of the Federation. They should call his successor, Governor Dodo, to produce Yahaya Bello, so that he can come and give account of the stewardship. This is as simple as ABCD. Well, they are not killing him there.
Well, obviously, a very emotive issue, Mr. Oshoma. But obviously, from your point of view, you're down the middle from a legal perspective. I mean, given all this emotion, all this drama that people are having to sort of wade through, is there any sense, given what you now know of the cases, the conflicting court, rulings and all the rest of them, court orders, any sense at all of when this case will finally get to court as a trial, or is that all a bit hazy at this point, based on what you're seeing?
No, but what would first and foremost, I sympathize with my colleague in the studio there, but I want him to blame the system that we operate in. But that said, now the court has set a date for ruling on whether to set aside the order for warrant for arrest. Until that matter is taken care of, EFCC can no longer take steps in the matter. That's the position of the law. Yahaya Bello can take steps, EFCC can take steps. On that day, the court will either rule that if Yahaya Bello, now he's been served, the court will either rule that now you have been served, we give you so-and-so date to produce yourself in court, because the EFCC chairman has said we can arraign him without it taking his statement. And so once that date is set, if he fails to produce himself in court, the court can issue a bench warrant against him that let the police IG or anybody that sees him hand him over to the police and produce him in court. That's the procedure of the court. And if the court refused to vacate the order, the warrant for arrest, then the EFCC can still go after him. But let me quickly address the absurdity that my colleague talked about the day EFCC went to his house. I am still at a loss, Charles, I'm at a loss. EFCC said a condo of an area waiting to arrest a former governor. And while he is there in the house, a current governor came and they opened the road for him. They didn't follow him in. They didn't even ascertain whether the vehicle that came, despite the fact that those vehicles carried the number, but that the governor was in there. Is the immunity, is it the convoy of the governor that is cloaked with immunity, or the governor? He went into the house and came out, and then they said, oh yes, the man came to take him out. Look, spare me all of these sentiments and emotions. If security agencies want to work in Nigeria, when it concerns you and I, they know what to do. All of this drama, backdoor invitation, and then that show of shame, then allowing the man to go to court, and then you suddenly realize that, oh, he played a fast one on us, he has an order. You say, no, I appeal the order. Now, as I speak today, they have withdrawn the appeal. The appeal against that order has been withdrawn by the same EFCC on the ground that they filed it out of time. If you know that you were filing the appeal out of time, why withdraw it? Why file it in the first place? So it is, unfortunately, it is EFCC that is entertaining people. And after all of this entertainment, you create loopholes and only so that you set up the judiciary to blame. You say, oh yes, the judiciary boggled your case. While in the actual sense, in the first place, you set out to prosecute, not to convict. Right. After all, the FCC chairman has also said he will prosecute. Okay. So prosecution does not necessarily mean conviction.
A lot to get our heads around there. Clearly, you've got your head around it, Liberus. We're not as legally up to speed as you are, but certainly thank you very much indeed for trying to put that in perspective. And also to you, Austin Okai, thank you very much indeed. Liberus Oshoma is a lawyer. He was talking to me there from Lagos, and Austin Okai is a human rights activist, and he was here in the studio in Abuja with me. Thank you both very much indeed.